Yes, Your Lordship. I beg to mention item number 29. Let this matter come after 2 weeks, Your Lordship.
You're a petitioner?
29.
What's the matter about?
This is only for interest, Lordship. This is the retirement benefit has already been paid, but I am claiming for interest, Lordship.
For this Vishwamitra coach?
Yes, Lordship.
Similar prayer for
Where's Mr. D?
It's on legs, Your Lordship. It's on legs before division.
Will be on like for 2 weeks.
30 connected, Lordship. 29 and 30.
1 week, yes.
Much obliged.
Yes.
Your Lordship, I beg to mention item 38. The conducting counsel A.R. Pasa is indisposed, Your Lordship, if this matter can come up after 1 week.
1 week as the uncounsel indisposed. He informed you?
Yes.
Much obliged.
Yes.
May it please Your Lordship, I beg to
Yes.
mention item number 31, my Lord.
For whom?
On
My
behalf.
lord,
Yes, Mr. Chanda.
my lord, in fact, they have informed that Mr. Nitish is out of station. My lord, next week, it is our case. Your lordship already noted.
Already?
Noted on two
Covered case.
2020. Covered case.
When's Mr. Dr. Mozieka coming back?
Most probably on Thursday or Friday, my Lord.
Have it after 2 weeks, Mr. Chanda. Yes.
My
After
Similar
2 weeks.
prayer for item number 32, my Lord.
32, 2 weeks, yes.
I beg to mention item number 41 as well, my Lord. If this matter may come up after 1 week, my Lord.
41. Mr. Chanda is there also?
Mr. Jha, prior consent has already been taken, my Lord.
Yes. 1 week, yes.
I beg to make a mention of item 33. It's kindly listed after 2 weeks.
Your father? Petitioner?
Yes, ma'am.
Why you would have done it?
But next date I'll try to do it, my lord.
Show the pinning of fine. Last time we took, it was a fixed date today.
My lord, I was not available on the last occasion. I did not appear.
Don't take time on this. This is 19 matter. 1 week, yes. 1 week, yes. Next time you
My lord.
argue it. Yes.
Only the stay might be extended till the next week.
Stay. Once you
I'll try to do it next week. my lord.
stay, that is discontinued. There's no more stay order after you didn't appear last time. Last continuance was on
I've made a prayer, my lord.
it was until 6/4. After it didn't continue anymore. Next week argue it. No need to say. They will not do anything in the interim. Yes.
Kindly, my lord.
Let it come next week. We'll do it. They'll give you some impetus to do the matter. Yes. Yes. That's it. One more thing.
Supplementary list, item number 1.
Who's for a petitioner?
So, BW ahead.
Now replace the petitioner list for tomorrow.
Much obliged.
2. Item number 2.
Please, Your Lordship.
Yes.
The revision application I was praying leave to have listed yesterday.
What happened in the trial court?
There's a trial. The presiding officer was not available yesterday.
Very good. See, Mr. Jandar will not prolong this matter. The understanding was that the matter will be taken from 22nd and then you have filed some kind of legal notice saying that order is revived. But I don't think that's very good in good taste.
Lordship,
Yes.
just two things, my lord. Firstly, this petition itself is prolonging the matter. It's an abuse
Yes.
of process, my lord.
So please, see, I expect that, as normal counsels,
We can close this matter with the
close the
understanding.
matter, yes.
We can, with the understanding, the matter is coming up today, tomorrow, whenever the PO joins back, and the matter will be heard and decided by the trial court. I will not press on that legal notice.
Yes,
So that
that's-
order which is under that may kindly be set aside, my lords.
No, for that a hearing is required, my lord. Such wide-ranging
See,
orders cannot.
it's like a de novo proceeding. So
Yes, my lord.
whatever that comes in the way that hinders it should go.
So the order of 22
See,
February.
the appellate order was set aside.
Yes, my lord.
On understanding that, and on your submissions, that we'll go back and like you not heard in the appellate court, and so at that stage it remained. We'll go back and not to revive the earlier order, whereby they had appealed against that restored the connection. That's the only thing.
Lordship, just one small submission. Against the order dated 22nd March, petitioner had filed an appeal.
Yes.
So there was an option available.
Yes.
There was an option available to challenge that order if they were aggrieved by that order. They exercised that option by filing an appeal. Appeal court passed an order in their favor.
Yes.
Honorable High Court, this honorable court interfered and set aside
Yes.
the appeal court order. So point being that that challenge has already been preferred by them against that order in question. At the end of the day, they are left with nothing because the Honorable High Court has interfered and set aside the appeal court order. Now they want to re-challenge that same order by way of revision. Lordship, that cannot be allowed. By way of this present revision, my lord.
No. What from what I understand is that is standing the way in view of your legal notice. Understand, saying that the order stands revived.
I withdraw
So
the
the only
notice.
thing is that you draw legal notice. The only thing is that you have a de novo hearing on the connection. That's all.
Absolutely. And in fact, my lord, the hearing has already taken place on 24th March. Hearing has already taken place. Thereafter, there was a question of submission of documents. It's for submission of documents. We have already filed the documents. They have to file their documents.
Who's Sharma Associates?
That was
What's the old one? Sorry.
old.
There's an old council.
Where's the new notice?
That is at page 155.
Last
lecture
page.
8.
If indeed it is this legal notice which is standing in the way, I withdraw this legal notice. We are not pressing on this. It was only issued for the reason that for weeks we've been sitting in the darkness. Something had to be done. So we withdraw this. We are not pressing on this legal notice. It's a legal notice.
No, you hear expeditiously, get it heard, and
No, I have no
whatever
difficulty
orders-
with that, my lords.
Yes.
Because what they're saying is that by Lordship's order of 6/4/23, the appellate court's order has been set aside, thereby reviving the order of the 22nd of February. That order is was under challenge orally.
The presiding officer is supposed to join today. Hearing can be conducted today itself or tomorrow, subject to
That
whatever.
is for her to look into
Yes,
it.
we can't really impose. They might have their own personal difficulties.
True. Yes. Point being that matters ripe for hearing. It will be heard today, tomorrow, day after.
This matter has been brought again before this court.
So this is one additional part. I have challenged two orders, my lords. Kindly have page 146. This is the order of 24/3/23. I had expressed my intention that I was aggrieved by this particular order. By the last part, the last direction. After the court had heard this matter, she was prima facie satisfied that the petitioner had not made out a case. But subsequently
How do you know
says
she's
relevant
satisfied?
documents. That's by what has been recited by the court in the body of this order. But subsequently, the court directs the parties to file relevant documents in support of the case. Now, neither of the parties have enclosed any documents.
The thing is that whatever it is, it'll be decided, on the materials available. Okay, we're not going to, enter into that, area.
Lodge.
The thing is that the only thing is there's any, irregularity in the order which need to be corrected. That's all. So the proceedings are not, they will go on smoothly.
So my just limited point, my lords, is that the court could not have directed the parties to produce relevant documents which are outside the pleadings. That is my only point. I'm not pressing this point at the moment. If lordships permit me to raise this point before the trial court.
No, you're free to
On the
raise
issue
any
of
point you
documents, The documents must be confined to the pleadings
So
of the parties.
that will not give any observations on that.
My lords. That's because if I do go back, the court will say they were allowed to file any documents outside of the pleadings. That's the only issue, my lords. Kindly see what the court directs. In view of the above observations made by both parties are directed to produce relevant
154.
documents on the next day. Now, what are these relevant documents? Because insofar as this miscase is concerned, there were no documents enclosed by either parties.
Lordship, as
So
far-
this would mean documents outside the pleadings, which may not be permitted. my
See,
lords.
if we say they have no case for reconnection, why should you fear the documents?
No, my lords, the documents are because I don't know what they will rely on. I'm not sure what they will rely on. So only, as Lordships had pointed on the last occasion, it is a case of course correction. The question is whether the court has the power to allow parties to bring in documents which are outside the pleadings.
If that is the case, then this matter has to be admitted. We have to hear it.
Lordship, I have no difficulty with that.
Lordship, just one point regarding this order. Lordship has already expressed Lordship's mind as far as this particular order is concerned. If Lordship turns to page 153, that is Lordship's
Order
last
passed
order.
by this court.
Yes, ma'am. That is Lordship's last order.
Yes.
Page 153, para 11 of Lordship's order. In these circumstances, therefore, to correct the course of the proceedings, the impugned order dated 6/3/2023 is set aside and the parties relegated to resume the proceedings before the court of the Assistant District Judge in Miss Case number so-and-so. It is further directed that the court of the Assistant District Judge, notwithstanding the setting aside of the impugned order, is to recommence the proceedings from the order dated 24/3/2023 in accordance with law, especially it goes on. So Lordship has already examined that order and expressed Lordship's mind that the proceedings are to recommence from this particular order. Now they appear to be aggrieved by this particular order. They want Lordship to change Lordship's earlier mind and to hold that order illegal or to interfere with that order. That amounts to a review, my lord. Their remedy.
So that's why we're not going to make any observations on that.
Absolutely.
You are free to make whatever objections you have.
Lordship, kindly observe that in the order. That's all.
You're
That's
free
all.
to make
That I
it.
can raise this particular issue.
Of course.
On the issue of documents. That's all.
Lordship's observation is not required, but
Yes.
by way of abundant
Well,
caution for
this
his.
will not end if Lordships don't make it clear that the order of the 22nd of February is set aside. Because now if they say don't set it aside, we will not press our notice. They might renew their objection in some other form. I'm not really sure what form that, but I can't anticipate that. So only if that order of 22nd of February is set aside very clearly, then we can proceed with the matter.
Lordship, to set aside that order, a hearing is required.
That's okay.
We have that order 22nd.
That's at page 139, my lord.
Okay.
Now, against this order,
This is past ex parte also.
this was
Yes.
past
Lordships,
expiry.
in fact,
Now, against
observed
this
that in
order,
the last order.
yes, against this order, they have filed an appeal. They had utilized their right of appeal. They filed
No,
an
it's
appeal.
understood that this order doesn't exist anymore.
Lordship,
Yes.
Lordship,
We'll pass orders.
Lordships.
Yes,
Only that
this-
clarity is required. That's all.
This matter has been brought again before this court due to a legal notice issued by the respondent dated 12/4/2023, whereby it has been stated therein that an order dated 22/2/2023 passed in so-and-so Miss case was still existing, and as such the petitioner was required to restore the electric supply to the premises held by the respondent. Stop. Next paragraph. Mr. S. Sen, Learned Senate Counsel for the petitioner, submits that in the earlier round of litigation, namely in CRP number so-and-so 2023, this court by order dated 6/4/2023 had relegated the parties back to the trial court to recommence the proceedings from the order dated 24/3/2023. Relevant part of the order dated so-and-so is at paras 10 and 11 is reproduced here and below. Stop. Of which stop. He submits that though the hearing was to recommence, in view of the illegal notice, the same has created an impediment for proper adjudication of the matter. Stop. It is also submitted that in the last order dated 24/3/2023, the learned assistant district judge had allowed the respondent to produce any other relevant materials in connection with the missed case for reconnection. Stop. Next paragraph. Mr. S. Jindal, learned counsel for the respondent, at the outset fairly submits that if the legal notice has caused an obstruction or hindrance to the adjudication of the matter, comma, the respondent shall not press the same, and that the hearing can recommence as directed by the early order. That's it. Stop. Next paragraph. I have heard that counsel for the parties as submitted by Mr. Sen and quoted above at paras 10 and 11 of the early order, this court had directed that the matter shall recommence from the order dated 24/3/2023. Stop. This therefore implies that it would amount to a de novo hearing on the matter, which, however, as it has not been explicitly mentioned in the early order that the order dated 22/3/2023 shall not come the way 22/2/2023 shall not come the way of hearing the matter. The legal notice has been occasioned. Stop. In this view, the matter is disposed of. In view of the concession given by the respondent, this matter is disposed of at this stage itself, at the motion stage itself, by directing parties to adhere to the order dated 6/4/2023, and it is further clarified that the order dated 22/2/23 shall not be given any what is the word? Weightage any further. Yes. It's also open to the parties to raise whatever issues is deemed necessary before the learned assistant judge.
Little indulgence, Manoj, only with regard to those documents, if that may be indicated.
Yes, you're free to raise any objections.
I have specifically challenged the order dated 24/3/23, since that is not being set aside or interfered. Just some clarity is required.
Whatever order is passed by the lower court, either he or me will have to
You're free to raise anything. I can't say that I give you a license.
We have the benefit of referring to the live proceedings in that case.
Yes. Highly obliged. Yes.
May I please? My lord, this is a condonation petition for delay of 4 days, my lord.
Reason? Yes, Mr. Kumar.
My lord, I appear for the state, my lord, and
Yes.
then Section 5 application has been moved. Section 5 of Limitation Act condonation has been sought, and Section 5 is not applicable to election petition,
Yes.
my lord, and proceedings, and election People's Representative Act is a self-contained code, my lord, and there are a number of judgments of Supreme Court saying that Section 5 will not be applicable, and therefore limitation has expired according to me on 15th of April, my lord, and they have sought 15th of April, my lord. Kindly see Section 81, my lord, of People's Representative Act, which says that the petition has to be filed within 45 days.
Yes, 45 days.
Yes, that's true, my lord.
Yes, and 86 says, my lord, kindly see 80.
Yes.
An election petition calling in question may be presented on one or more of the grounds specified in subsection so and so by any candidate or any elector within 45 days. My lord, the date of election, date of declaration of result is 2nd March, my lord. Kindly 2nd March, my lord.
2nd March election.
As per the 2nd March 2023, my lord, and 86, my lord. Kindly see 86.
Yes.
The High Court shall dismiss an election petition which does not comply with the provisions of Section 81 or 82 or Section 117. 81 says, my lord, 45 days. It has to be challenged within 45 days. And 86 says, my lord, that if it does not comply with the provisions, it has to be dismissed. It shall be dismissed, my lord. And kindly see the judgment of the Honorable Supreme Court on this issue, my lord. 1993, 1 SAC 636. My learned colleague will hand over a copy, my lord. Or the first judgment, my lord, kindly see this 1974, 2 SAC 151. And straight away, my lord, paragraph 25, my lord, your lordship can see paragraph 25.
Which one? 74 judgment. Para?
These are 25, my lord, straight away. Of the Hukum Dev Narayan matter, my lord. For all these regions, we have come
One
to...
second.
I'm sorry, my lord.
Para 25.
Yes, my lord. That's 1974, 2 SCC 133, my lord.
For all the reasons.
Now,
Yes.
for all these reasons, we have come to the conclusion that provisions of Section 5 of Litigation Act do not govern the filing of election
Mr. Gaur, you have the
or
judgment?
their trial.
I got, but my lord, actually this judgment is of 1974, my lord. Thereafter, my lord, many things have changed. Sometime maybe let this matter come some other day.
Let them file objection.
And the,
You meet the objection.
your lordship say question. Yes, it's a legal issue, my lord. I will file it, my
File
lord. But
objection.
on 1990,
Yes, case, Miss Election Petition number 1, 2023. Stop. This is an application seeking condonation of 4 days delay in filing the connected election petition. Stop. Next paragraph. Mr. A. Kumar, on behalf of the respondent.
number, my lord, respondent, there, state respondents are there.
2 to 5 brains ones allowed to file a short objection to the said application. This up to 2 weeks for hearing objection. Yes.
Obliged, my lord.
Item number 4.
Yes.
Well, I've completed the
Checks
instruction.
ready. You give to Mr. Nyota.
Well, I've taken the instruction, my lord. They are ready to pay, but some time may be permitted to us, my lord.
1 week.
1 week will be too, yeah, my lord. I'm paying for 45 days.
It's a small amount.
I know, my
I
lord.
was
but-
waited for so long.
I know, my lord, but I had the instruction, my lord, that within 45 days will, or 30 days, my lord. Within 30 days.
With interest.
My lord, there is nothing to give interest, my lord. In fact, we are not getting salary for so long, my lord.
Mr. S. Day on instruction submits that the
On being instructed, my lord.
on instruction submits
my lord.
that submits that the amount due to the petitioner shall be cleared within 30 days from today. That's it.
But
Yes, Mr. D. Nyota is present behind the petitioner. Has no objection to the said submissions. According matter disposed of with as undertaken by Ms. S. D. on behalf of the respondents that the matter should be cleared. If not later than 30 days.
not later than
30 days.
30 days, yes.
I mean, sooner you can do it.
I will take a
Matter
personal
sensitive.
Meanness, item number 1.
Please, your lordship, this matter may be come up 2 weeks, my lord. Some development is coming in.
You're for the state, correct? No.
No. I am for private.
Only thing is this, I will request my learned senior friend, he should not appear in this matter. Otherwise the instruction that I have, my lord, is, I don't know to please, is not wise, my lord. Because my learned friend has appeared for the petitioner on the first round of litigation. Now he is appearing for the respondent, my lord. It took very bad on the part
No, because it has been withdrawn, my lord, 2 times.
even if it is withdrawn, my lord, he was holding the brief, my lord, of my client. And my client
Junior will appear, no problem.
No, not that. You can't make a submission. Ms. Hazarika is part of decorum and
it's the
ethics.
same, my lord, same
It
procedure.
comes like a bar council matter. Yes. We have
Some other day.
2 weeks.
Let it be after 3 weeks, my lord, because already the matter has become infectious as per my understanding.
3 weeks. Request Ms. Hazarika.
May I please, lordship?
Yes, Mr. Kumar.
My lord, item number 2 and 3 are similar matter, my
He
lord.
doesn't file affidavit till now. What's
Your
happened?
Lordship,
Yes,
Not yet, ma'am.
I'm praying for further 3 weeks' time, Your Lordship.
why? When was matter filed? 22.
They are
We have to
taking
make this
time
a
again
Allah
and
come here.
again.
When do you file for Khalat? 10th of March. We'll give them some more time then. 2 weeks further time as granted to the respondents to file affidavit.
My lord, my lord.
4,
Deeply, your lordship.
4,
Yes, Your Lordship, you see, this matter is regarding that village regarding the village Contempt has been included in where the matter has been delayed for almost 11 years, Your Lordship, where the district council has directed to hold a referendum, but again by order dated 10, 11 Feb.
Lordship, in fact, way back on, Your Honor may have a look at page 52. This is a translated copy of the letter dated 10 April 2018. Way back on 13/3/2011.
No, this is 52.
Page 52, Your Lordship.
This is, sir,
Translated.
reference to letter dated 17. Finally, Sri Young's can. Yeah, yes, what do you want to say? What is this? What is this document?
This
Is
is
it an order or a letter?
It's a letter. Actually, Annexure 13, translated copy is at page 52.
No, because I'm reading the original one. It says that is a reply with the Darbar. So is it a letter or is it a
It's some sort of a
conveyance of the resolution of the Darbar?
a letter written by the Darbar to the Executive Committee. So what I'm trying to project here, Your Lordship, is that out of 23 household, out of the majority of the locality Maukning, there are a separate village have been created from separating from Madan Lingdo. Now this household, the writ petitioners, a few numbers, 23 or maybe 30, they refuse to come with the new village, Maukning. Neither they are in the parent village, Madan Lingdo. Now the question is this, that at certain point, the Executive Committee has directed the same to hold a referendum. So this referendum could not be held for some reasons or the other, basically law and order. But be that as it may, by way of letter dated, this is at page 69, Your Lordship, translated copy, the last page. By way of this letter, the Executive Committee had written to the chief to to keep in abeyance the public referendum. So at this stage, my submission is that let the matter be referred back to the same to hold a referendum as per the original direction.
See, your village name is?
No village name.
Not village. How many people are there? You, this Champang Ranja, and he's representing whom?
Champang. Here, what happened, Your Lordship? This during for this whole parent village Madan Lingdo, Your Lordship. There are 7 units, Your Lordship. There are 7 units. Kentot, Your Lordship. Dong Madan Shat, Mauspung, Maukning, Mautulup, Dong Gawa, and Lum Knya, Sinya, and Wak Shat Ninja. So, Your Lordship, what happened in the?
No, they included you all with Maukining.
Yes, Lordship.
You don't want that.
Yes, Lordship.
And then now you're on your own because Madan Lingdo doesn't want you back anymore. So.
Now what happened, Lordship? During previous year, the parent village used to issue for us regarding essential certificate.
Understand?
Yes, Lordship.
Understand. Now you are part of Madan Lingdo. Now you made part of Mokening.
Yes, Lordship.
You don't want to be part of Mokening.
Yes, Lordship.
So Mokening doesn't accept you now also.
Yes, Lordship.
And so you want to go back to Maranlingdo, I don't accept you
Yes,
also.
Lordship.
No, there's no question of Mokening not accepting. Is they
objected. They don't want to be part of Mokening.
Because there are 7 units without consulting us. The 2 units, Lordship.
What is your locality called?
When is
You said how many households are there?
31, Your Lordship.
31 households. That means how many souls are there? How many people, population involved? Approximately, you say 5 per household. It'll be around 150. Okay. Anyway, what's the name of your locality?
Wak Shat Yengjai, Lordship. Madan Shat. The 31 households include Madan Shat, this control of Madan Shat, and Wak Shat Yengjai, Lordship. 2 units, Lordship.
Wak Shat Yengjai?
Yes, sir.
What name is that? And?
Madan Shat.
Now this petitioner, he's in which way is he representing all of you?
Your Lordship.
In which, how is his capacity?
Lordship, because he's a residential, Lordship. We are we are being aggrieved with, we are not in the parent village or in the newly, we don't want to be.
No, the thing is that I understand your grievance.
Yes,
you say that at one point of time,
yes, sir.
When they decided that they'll have the to create Mokening into a separate and new village, without consulting the 31 households,
2 units.
You were included with the Mokening village, which you objected
yes,
to.
Sir.
So you went and represented against that.
Yes, sir.
Then there was a referendum that had to be held by the
Yes,
district
sir.
council at certain point of time. Now, after referendum was given, nothing was done.
Yes, sir.
And in fact, by the last order, they said keep it on hold.
Yes,
there might be a problem, and so it stayed at that.
Yes, sir.
And you're suffering because you're not getting your
Either
permanent
Yes,
residency
sir.
certificates, and are you waiting on the schemes? No.
Yes, sir. No, Your Lordship, the schemes you're not getting.
That's
only the residential and the commission ground, the cemetery we are getting from Madanlingdo, the parent village.
I mean, to bury your.
Yes, Your Lordship.
How do you resolve this, Mr. Ganta? And sending it back to CM will take another 5 years for them.
Technically, Mokening was originally a locality.
No, you understand. That's
a new village has been
Maranlingdo
created.
and Mokening have no quarrel. Like Mokening is kid own village, Maranlingdo has no quarrel with that.
And
It's well and good.
technically-
The only thing is that these people who have fallen in the middle, they don't want to be part. They want to go back to parent village.
If they think,
won't you accept them back in the parent village?
Yes.
Because they don't want to obey the condition. And on 8/1/2013, there was a DOMA resolution, Your Honor, in which we have told them that if they want to be part of the parent village, they have to obey certain condition of the parent village.
What are conditions?
Just to obey, to be part of the DOMA, to obey the condition. But then they have straight away said that we won't obey the.
So what do you want then? You want to be part of Maranlingdo, or you don't want to obey the?
No, Chief. Because the state, because Mokening, it's not that Mokening village has written a letter to Madanlingdo, not for us not to issue any residential certificate, not to. Mokening village has put an objection, Your Lordship.
No, that's Mokening has written to Maranlingdo not to give you any certificate.
Yes, not to include us, to give us any benefit.
I think it's better if you call some sort of mediation.
Yes, Your Lordship. If the discouncil can take up, the CM then will be delayed.
CM will be delayed.
Yes,
you
sir.
take it up again. Just one meeting.
And any
use your good officers, yes.
Any speaking order may be passed, Lordship, so that the matter be settled, whether we're getting or not.
Lordship, actually, in fact, the chief, that is of Khadim Samship, who's the main party to.
He doesn't appear, so we have to disregard that his non-appearance. And if these people have come to court and we're suffering since when this
The
thing
point
happened,
is this, Your Lordship, what do they want? They want to be with Mokening or
they
with
want to become
Madanlingdo?
part of Maranlingdo.
Then let them go back to Madanlingdo.
No, Your Lordship, they are not accepting because there's an objection for Mokening. Let this council mediation, Your Lordship. Then, if we go back to Madanlingdo, there'll be the order will be there, and any sort of order.
No, they have any grievances if they go back to Madanlingdo?
That I have to take instruction because as per the resolution, you have already said that they are not part of Madanlingdo.
We'll do one thing. Take down.
Please, Your Lordship.
Yes.
Lordship, I appear for the respondent number 6, the Mokening village, Lordship.
Have you objected to them going to Maranlingdo?
No, Your Lordship. There's no question that we are not allowing them to be a part of our village. It's just that the petitioners themselves, they want to form a new village, Your Lordship. They want to form a new village.
Is that correct, Mr. Krim? You want to start your own village now?
No, Your Lordship.
They want to create an own village, Your Lordship.
At least we should not be. If we with parent village, we are ready, Your Lordship. That's not that.
You ready to go to Mokning?
Your Lordship.
Ready to be part of Mokning village?
Mokning, no, Your Lordship, because there's a.
No, are you ready to be part? Okay, which you toss a coin then. Heads go to Mokning, tails go to what's that modeling door. Otherwise, you'll be nowhere.
So that the issue may be settled if I agree that if the matter be mediation by the
no, mediation are all right, but the thing is that you see, Mr. Nongpur submitted that they have no objection if you come with them, or no have the reason objection against you joining Bundling Door.
That's why, Your Lordship, let this matter come for mediation. Let the matter be settled. Let this
who will represent your villages?
These people will come, Your Lordship.
You agreeable to that? You agreeable to let the Sardar headman of both your villages and let them appear before
this council.
Yes, this is council.
Let the concrete order may be passed, Lordship. That's the only blessing.
If you can finalize it, Mr. Kanta, it's a simple matter.
Why not before the same?
Same will take time, Your Lordship. That's why
before the chief.
The chief in this report has recommended us for
We are
a
an
separate
appellate
village.
authority, Your Lordship, at the end of the day.
Doesn't matter. You have all pervasive. You have all pervasive power.
I have a suggestion that let it be mediated by the chief, Your Lordship. It be the right authority.
Your Lordship, the report submitted by the CM before the executive committee is to give us a separate village. That's the report number. The point number stated number.
Where is that?
That's the letter, page 52 only, which have
translated copy at page 59, Your Lordship. Point number 8. Page 59. Translate copy at page 59. Point number 8. I've highlighted.
These villages, which part of Khairam Simship are they located?
Khairam Simship near this Peninsula side. Near this Peninsula.
That side, not boy side. Khairam is a big Simship.
that's why till Nagaon.
Not Khairam. That's Milliam.
Yes, Your Lordship, Harim also. And Kamrup, Brahmaputra.
What do you say about this letter then, Mr. Kanta? That the ball's been thrown to your court only.
We also have suggested that it should be a referendum.
Don't forget the referendum. We'll take down that. Yes.
Submit.
Yes.
Lordship, may kindly come to page 63. Page 63 of the writ petition. Now, this is the letter from the CM to the Deputy Secretary of the HTC, Lordship. Lordship, am I allowed to read the contents of this letter? This Darbar has sought the explanation from all the elders of Raj Nokindri. A meeting was held on 28/8/2020 at Smith Village, in which Lingdo Elementary has shown their difficulties to create a new village for the 30 household, because in the said area in which the 30 household are residing also includes 20 household who are with and under Maukining village. The difficulty is that no proper boundary and demarcation can be confirmed at present, but only if the 20 household are willing to join together with the 30 household. Till date, it is understood that the 20 household are not willing to join together with the 30 household, but to remain within Maukining village. So the Darbar understood that it has to wait and relook into the demand of the 30 household.
Serious?
That's why let it meditate.
We don't understand.
The only thing for you is you drop your demand for separate village. You have to go from there and you decide where you want to go. That's it.
Serious issue.
No, you forget your demand for separate village. You take instructions.
Okay, Your Lordship.
This matter was heard at some time for some length. Mr. B. Kiriam, as also the respondent number, Mr. You have 5 and 6.
I've got 6, Your Lordship.
6, including the district council to obtain instructions. Now you make up your mind. Once you make up your mind, you tell your people if there's no question of separate village.
Yes,
the courts express that, and it's a decision of which way you want to go. That's it. And we'll pass orders, and district council will affirm it. It'll end your problem also.
Item number
After
5.
2 weeks.
2 weeks. Yes, after 2 weeks. Yes, on soon.
5.
May I please, Your Lordship? Your Lordship, I have filed this affidavit of service of notice. It has already been served, and report is.
Have you filed a joinder to the?
Yes, Your Lordship, I have filed.
Yes.
And for the respondent number 5, Your Lordship.
What about number 6?
I have
Service report.
service report. I have filed, Your Lordship. It has been served, but she has not appeared.
An affidavit of service has been filed by the petitioner indicating service of notice upon the
Respondent number 6.
respondent number 6 on 11/3/2023. Stop. However, no appearance is made on behalf of respondent number 6 today. Submitted by Mr. Pandit, that rejoinder has since been filed to the affidavit filed by the respondent number 5. This is matter after 2 weeks. We just give one more chance.
Yes, Your Lordship.
This one for appearance of the respondent number 6 and for further orders. And so and so.
Item number 6.
Also, these are those batch of land acquisition matters. They're all
Yes.
listed today. Kindly have the order dated 23/2/23.
Not this matter. 23 to?
No, it's, in fact, in the whole batch of writ petitions, any one of the other writ
in which
petitions.
WPC is passed?
It is 14, 15, 16, 25, that item number. Item number 14 also.
16 lordships may kindly peruse. Item number 16, that is Anup Sangma.
Yes, where's DSGI?
Your Lordship, he's currently out of station, Your Lordship, and with regards to the status of regarding the inquiry that was held by the DSF, we have not received it. So if this matter can kindly be listed along with the other matters in the hearing list after 1 week, Your Lordship.
Not hearing list.
Your Lordship, there are 3 connected matters.
There are a few matters from the hearing list. which are-
27.
No, I mean, this matter won't come to hearing list.
Lordship.
When's he coming back?
Your Lordship, let's see.
Yes, MSS from Thao. Vice Dr. Muzika submits that the inquiry report is yet to be made available to the learned DSGI, who is also not present today. She prays for and allowed
2 weeks maybe.
list just stop this thread, list the matter for 2 weeks along with other connected matters.
Yes.
16 to 28 minutes.
16.
14, 15, 16, 25, 26, 28, 27. Lordship.
Item 7. 7.
As well as Lordship.
Please, Your Lordship. Your Lordship, I'm praying for some more time, Your Lordship. We've received instructions where there are some documents, Your Lordship, supported documents that are required
Yes, documents for?
for the affidavit, Your Lordship.
Where is this file? When was the petition filed?
December 2022, Your Lordship. We'll be filing, Your Lordship.
What about numbers 6?
In
in the course of the day we will be.
No, and you obtain status of service on respondent number 6. What happened?
7 has entered, Your Lordship.
7th appeared. What about number 6? You obtain status, Mr. Basmatari, correct? And Basmatari. Hermoso submits that he has not been, the petitioner not been able to obtain a status of service on respondent number 6. Stop. He prays funds allowed further 2 weeks' time for the same. And file service affidavit necessary. Stop. Next para MS Ilingwa on behalf of respondents 1 to 5. And where's the other? Praise funds allowed 2 weeks' time to file affidavit. None appears behalf of respondent number 7. This accordingly. Also.
8. May I please, Your Lordship? Your Lordship, here the respondent number 1 to 3 are yet to file the affidavit, Your Lordship. Sufficient opportunity has been granted, Your Lordship. It's a pension matter, Your Lordship.
May I please, Your Lordship?
You are appearing this matter?
Your Lordship, I am substituting Mr. Abraham. He is on sanction leave, so.
Doesn't matter. All government is one government.
Yes, Your Lordship, but 2 weeks' time may be granted to file the reply.
First, let's see. From in order 15/12/2022. That instruction will be received, and a petitioner, if so entitled, necessary steps shall be taken to the department concerned at the earliest, even prior to filing counter affidavit, is that they release a pension if entitled. See the order, 15/12.
I have received this, Your Lordship. I have received the file yesterday only.
Doesn't matter. Then 1/2/2023, 2 weeks.
Your Lordship, I will
24
be allowed to file reply. 2 weeks' time may be granted. I will file myself.
Then another 2 weeks, that means 8 weeks. Then again 8-10 weeks, more than how many months?
Why almost yes.
Since last year. What to do?
2 weeks' time may be given.
No, I mean, are you filing affidavit or will you just pass orders?
Your Lordship, I have seen.
What's your case?
Some pensionary benefits
You
are
have
not
got
given.
instructions.
Yes, I have received. I have seen it is inside, kept inside, but only leave salary has been already issued. But other retired pension.
Let's see, we'll dispose of the matter. There's too much affidavit. We have received instructions, and I've noticed this panel is very disconcerting, especially for these pension matters.
Sometime maybe when I'll find myself.
I want to see when instructions received. This is January 23, given on this, whoever
4 months.
6 April received. Take down, yes. We'll dispose it off. We'll dispose it off, I think, better. Why should we wait? Yes. Yes, take down. The petitioner who retired as
Head assistant, Your Lordship.
she retired as, where is that? Retired head assistant from the office of the Public Works Department on 31, retired on
31st December
31st December 2022. Stop.
2020.
2020, sorry. And before this court for non-release of retirement benefits and pension. Stop. And this matter had been left hanging due to the instructions and affidavit that was to be received by the learned government advocate, which, however, till date, in spite of several opportunities being granted, has not filed the same stamp. MSS Bharatsaji today, who appears on behalf of the
Conducting counsel, Mr. H.
Counsel, Mr. H. Abraham, so which has no instructions, but that the instructions as received she has no instructions personally, but has handed over a set of instructions as received from the department staff. Next paragraph. A perusal of the instructions, which are dated 25/1/2023 and submitted on 6 April to the Government Advocate, reflects that the leave salary of rupees 5,79,040 rupees 040 has been released, has already been released, sorry, on 23/3/2021 by office order number 14, and the GPF of rupees 8,07,445 has also been released on 21/10/2020, and the only parts remaining to be settled is the remaining terminal retirement benefits of gratuity and pension, which is under process now. The instructions also further show that the delay in processing the term benefits was due to the corrections and regulations needed to be done in the service book of the petitioner. And that on 13/1/2023 by office letter, here quote is now, by office letter PW stroke CE stroke ESTT stroke 4 stroke 2021 stroke PT 131, the regularization of the service books and other pension papers of the petitioner have been received by the office of the Chief Engineer, PLOD Roads, Meghalaya, and as such the DCRG and the pensions now under process. Stop. Stop. Next paragraph. In view of the categorical instructions that are contained in the instructions that have been given by the Office of the Chief Engineer of the Roads. So this matter did not necessarily be kept pending due to the absence of an affidavit. So, but accordingly, this matter is disposed of with the directions that the respondent shall complete the remaining process as expeditiously as possible, preferably within
3 months.
3 months from the date that this order is presented before the Chief Engineer Roads. So, with the following directions, matter stands disposed of. You take back the instructions. Or I'll just keep it, I'll return it later on. You have to just cross-check. No point if the instructions are there and I've what affidavit? Poor person waiting for pension, again filing affidavit, again take another 4, 5, 6 months.
9.
Yes, record EV Passage, present we have respondable for. Sorry, Fanny.
Lordship, this matter is still pending before the Honorable Division Bench. I'd like to pray another 4 weeks' time.
You said last time you submitted that you can be settled amicably.
Yeah, we work, in fact, we made that, we extended that olive branch, but it was not reciprocated.
See what's going to happen. Both of you are going to lose out.
So
If a third party comes, if a third party knows how to play the ball,
No, we wanted to discuss.
Both will go out. Darbar and Sankra will lose it. Even you will have no claim, and there's another. You are paying for whom?
For 4 and 5, my lord.
Yes.
I've informed Mr.
Supplementary affidavit in the cooperating documents will never end. Anyway, there's no suit filed as yet. No. Yes, on the prayer of the counsel with the parties of the matters at the writ appeal is still pending for division bench. This matter of the 4 weeks.
10.
Yes, Mr. Chaudhary.
Well, in this matter, an affidavit has been filed, bringing some official proceedings. If the matter comes up for final disposal, in the meantime, we'll just explore if
what is there to dispose?
rejoinder is required.
My lord, the impugned order 1411/2022 says, my lord, that we have not conducted DPC. A submission was made, and my lord, lordship has directed to conduct within 2 months. So, my lord, we have conducted, my lord, though there was a delay because of the model code of conduct, my lord, but we have conducted, and I have placed that on record via the affidavit, my lord, which is at page 5, annexure A, my lord.
Yes.
My lord, the outcome.
I have also submitted that I am told that an affidavit has been filed, my lord. So, matter may come up for final disposal. In the meantime, my lord, whatever has been submitted, even if rejoinder required.
Take instructions, Mr. Chaudhary, as per last order. We go by last order only. That time you were not there. So anyway, we'll have it after 1 week.
But the only thing is that if necessary, we'll file a rejoinder.
After 1 week, yes.
After all, first.
11.
For the orders. You're going to file it by the time we file it.
But, all right.
Please, my lords, I am for the respondent number 2, and in this case, I am supposed to file my affidavit. However, my lord, on going through the records, it appears that without filing my affidavit, so this case can be disposed, my lord. Because why? The grievances of the petitioner is page 24, which is the order, is the product of the order passed by the.
1 second. 1 second. Yes.
May I please, Your Lordship, in the meantime, I may be allowed to make submission that Mr. Abraham is on sanctioned leave, Your Lordship. So I do not have file also. So, Your Lordship, may I please.
Let's hear what he has to say. Is he the concerned? What's the matter about?
My lord, in this case, the petitioner is aggrieved by the order passed by the governor directing the deduction of the 50% of the petitioner retirement benefit in favor of the respondent. which
By
is
writ petition?
side by side. Yes, it is side by side, my lord. Another petition has been filed by the petitioner challenging the order of the judicial magistrate. Means the order passed by the governor is the product of the order passed by the learned judicial magistrate in
You
MCR
draw it
case.
then.
That is
Your
directed.
Lordship, it can be disposed of like observation that this order, page 24, will be subject to the outcome of
the criminal.
Where's
criminal
this
revision.
page?
24.
Yes, Mr. S.M. Suna, Learned Counsel for the respondent number 2, submits that the impugn order dated 19 December 2022 is only the outcome of
the
proceedings.
Of the proceeding of the MCR case number.
Proceedings of MCR case.
MCR case number 3 of 2020.
Number 3 of
2020.
2020.
And the order was passed in
2020 passed by the court of the
Learned Magistrate.
Learned Magistrate, District Council Court.
District Council Court. Whereby by the order dated 30 September 2022.
Listen, sorry. Outcome of the so-and-so, of the what?
The order dated 30 September 22.
Is outcome of the outcome of order dated? What's the order?
30 September 22.
30 September 22 passed in MCR
case number 3 of 2020
by the court of the by the executive magistrate or by the magistrate.
Subordinate district council.
Court stop. Next paragraph. Ms. S. Pandit. Ms. S. Pandit in reply thereto submits that as this is Ms. S. Pandit accedes to this position and submits that since the order is under challenge, already challenged the order.
Yes, Your Lordship.
Since the order in question, that is, give the date again, 20th September.
30 September
2022 is already under challenge before the court of the judge.
Yes.
In a criminal revision petition.
Before
the criminal, before the High
Revision
Court.
petition number 7.
Criminal revision petition number 7 of 2023.
It's already under challenge in a criminal revision petition before this court, being criminal revision number
7 of 23.
7/2023. This matter will be close to its outcome of that matter.
Yes, Your Lordship.
Accordingly, matter stands closed. Yes, I'll dispose of.
Highly obliged.
12.
So the grievance was for promotion, my lord. He has been promoted. I'm only praying matter can be closed in his back wages and all those benefits. They have given promotion with effect from 7th of July 2022.
Why? What's your claim for retrospective promotion?
There is no such claim, Your Lordship.
Then?
No, because we had approached before they promoted us.
Before the?
Before they promoted, we had challenged the DPC was held, my lord. They rejected our claim. We substantiated our claim as to why we should be promoted.
Then what back wages you'll get?
No, because they have from 7th of July, my lord. So that we did make it up.
You file a separate thing then. Mr. S. Dev, General Counsel for the petitioner.
Instruction of the client.
Instruction of the client, that means, you know one thing, what is being a counsel? Being a counsel doesn't mean that you're just a mouthpiece of your client. Being a counsel means you take instructions from your client, you distill the facts, and then you make submissions. And always, there's some lawyers who go and advise of the client only. That means the client always have the best case in the world. You go and advise the client only what will happen to you.
Why I'm saying, my lord, is that
jumping off a cliff. You have to use your own legal mind.
Is that initially he filed a petition.
See, the thing is that you have to see whether he's entitled to any relief.
Yeah, that's
Whether
what
it's you can substantiate the relief that is claiming. If a client just says, I want the moon, and you say, Lordship, I want the moon, my client said so.
Actual background is not as such.
Is that possible?
No, but why I've said that, my lord, is that initially a writ petition was filed because he was given a bad ACR. After filing the writ petition, the respondents have expunged it, they have recalled it and given him the proper ACR. Based on that, he sat for the DPC, my lord. The DPC rejected him, saying that you have not gotten the qualifying marks or something in that sort. Thereafter, again, we challenged the DPC proceedings, saying that, my lord, the
No, then there's no question. You'll come to deal with DPC in the promotion. If for some reason which they didn't hold a DPC or the other people similar
now
to
they have done it, my lord.
yes, Mr. S. Deb submits that as the petition has since been promoted, nothing suffices for consideration of petition. From any other entitlements which he claims, he submits. Forget it.
I may be at liberty. That's all.
He submits. He may be given liberty to agitate for any other entitlements he claims. Accordingly, on submissions of the petitioner, matter stands closed and disposed of.
Obliged.
13.
Is for hearing.
Yes.
Hearing.
In this case,
earlier it was posted for hearing.
Then
what happened?
To file some document, then
Who wanted to file documents?
Your Lordship, in this case, inquiries took place, and this government has filed some documents here in the inquiry report. But I think there are some documents yet to be produced, because in this case, Your Lordship, the person who is conducting the inquiry, this report is not there, it is not available. But the person who has went and inquiry took place, and for the inquiry, this record is not available there, Your Lordship.
the government affidavit is very clear, Lordship.
Your Lordship,
Because he is the SMC appointed teacher.
No, please. I'm not clear about anything. Yes, what do you want to say? What happened in this case? There was an inquiry done by whom?
Your Lordship, there is.
There is inquiry by the government.
By the government. By whom? SDSU.
It's a report, Your Lordship.
By whom?
I may be stand corrected. Your Lordship.
What has happened is the petitioner claimed for salary. The issue was that there was a claim and counterclaim for the same salary to teachers.
Okay.
So inquiry was directed to it. The inquiry was conducted by the submitted to the district teaching coordinator, SSA, and that inquiry report has been submitted. What has come out is that there are two orders from this honorable court of two different teachers, both claiming for the same post at the same time, and that's why there is a deadlock.
So what happened to the other case?
Both the matters had been disposed of in motion stage with direction to the SMC to revise the salary for the same period.
For the for the teachers.
Two different teachers.
So what have you done against that? Have you sought review of the orders?
No, we have represented to the state respondents to give us a clarification, but it is stuck in a deadlock.
So how do you give a clarification if the orders are wrong? Because sometimes what happens when matters dispose of motion like that also, it's on the just prima facie satisfaction.
Government affidavit is very clear. What are the criteria?
No, you mean by this case now we're going to decide who's entitled to the salary? Yes. You say you are entitled. Yes. And Mr. Debnath says he's entitled. Yes. Which case did you come for this court earlier on?
This grievances here, Your Lordship.
No, I don't want to grievances. We know your grievances, that's why you're here. The only thing is that where was the order of this court where said the entitled to salary? It's directed for payment salary. Where's that?
Your Lordship, in my petition, there is no order as such.
That's there in the inquiry report.
Where's the inquiry report? Okay, let's see.
Your Lordship, I may stand corrected.
Administrative come accounts will be.
One second. Just pipe down. No, where is the inquiry report? What is this?
Last time, Your Lordship, I have submitted one report saying that is the inquiry report, but it is just a report, Your Lordship. It is not inquiry report. This
so
is a report. One bunch of.
I will be bringing
7th March 2023.
One second.
Submitted on 10th. Submission of report 10/3. It was submitted on 10th before the honorable court.
Okay. There's an order of 2019.
The first order in this instant matter was passed in favor of the petitioner.
In this case.
To release the salary. Whereas before that also, my lord.
This 50. Okay, this order is dated. This is in the report. It's legible. 5/3/2019. Right. It says that since Mr. K. Barwa, so and so, the petitioner submits that the government has released the salary of the petitioner, but it manually is not deposited in the account. Even so manually. So after this order, what happened? You receive your salary?
No, Your Lordship. Till date I didn't get married.
Very good. And then, and in your case, where's the order?
That is in my
Prior to this 19. So Mr. Sheikh's holding one order in his hand saying I should be paid.
Yes.
And he has his order 5/19
In this case.
that the money has been deposited in the managing
It's the
committee. to
interim
pay.
order, Lordship.
Right, it's interim order, yes.
Now
Has this been vacated?
No, Lordship.
Then?
And my one also final order that they have not complied with. My order was earlier than this one.
Let's see affidavit. That earlier, but
Government
then.
affidavit is very clear, Lordship.
Lordship, in this case.
One second.
Government
Just
affidavit.
at least let be clear where's the affidavit?
Government affidavit paragraph
Where
5.
your affidavit?
My affidavit, Lordship.
Where the order is there? Where's the order contained?
Yes, Lordship. That is
Whose affidavit?
That is a Lordship.
Thirty 11,018 is eligible. You can't read this order. Yes.
That is 30/11/2018, Lordship.
You're Abdul Salam Sheikh.
Yes, Lordship.
Where's then your affidavit? Dated.
My affidavit, Lordship.
So your order for salary is 5/3/2019. Correct. Okay. It's an interim order. Right. Then where's the affidavit?
My affidavit, Lordship. Filed on
Respondent number?
Respondent number 10, Lordship.
Filed on 23rd of
February 2022, Lordship.
Okay. Page?
Order is page that 32, Lordship.
$32.
Yes, Lordship. Respondent number 10.
17, 18. Oh, I've got the affidavit. 29. Yes.
Till March 2020,
One second.
2018.
Okay. Right.
Then till March 2018.
Doesn't matter.
Salary directly credited into my account. Then subsequently, my lord, 5 months
2018. And then 5 months salary after given.
given to her account.
After 2018.
That is on
See,
Lordship.
you were paid till March 2018, you
18,
say, right? Then after that, what happened?
Then 5 months.
From March.
From April, May, June, July.
Okay.
And August, Lordship.
June, July, August. Not you was paid to
Instead of giving me, Lordship, from the office,
paid to Jebunessa.
Jebunessa, Lordship.
Okay. Then after that, after this order,
Now I come to the court, Lordship.
then after you're paid, then after
Yes,
that.
Lordship.
You're
Then
paid.
subsequently, I have not been paid, Lordship. I have not been paid after that. Because after this order, my lord, they have come to the court.
No. You're not, okay, 5 months was paid to Mr. Devnath, correct? So after that, it's not paid to you. After this order, 30/11/2018, no money has been paid till date.
No, Lordship.
Very good.
Then they have approached to the court. When I have obtained this order, when I communicated the order to the managing committee as well as the department, then 19 they have
Right.
filed the writ petition.
Then
the government, my lord, Government has filed the affidavit, Lordship.
No, okay, fine. Then what happened? After, did he get salary?
In my case,
No, I don't want. Did you get salary after when you after
no.
you? Okay, enough. Yes, government. Yes.
May I please say affidavit filed on behalf of the government, Your Lordship?
Yes. Where's that? Filed on?
3/4/19.
Okay, right.
April 19, Lordship.
Yes. Natai Pada Bhumik. Yes.
Is a project?
Yes.
Start from para 5, Lordship. Para 5, Lordship.
Second paragraph.
Let us submit this. Where is your teacher who's been rightfully appointed? Where is the paragraph?
It is in para 5, 7 paragraph, Your Lordship. Subpara? No number.
Para?
Paragraph, page 2, paragraph 5, subpara.
Development.
Yes, that besides, Your Lordship. Page 2.
Besides, huh?
Actually, Your Lordship, as far as I said, there are 3 sanction posts.
Correct. Then who is the sanction teacher then?
So, Your
Well,
Lordship,
the para is clear, Lordship.
No, Your Lordship, may kindly see the annexures, Your Lord. Annexure 2. Annexure 2, page 8. She is an SMC appointed teacher, Your Lordship.
Who Jabunessa?
Jimunesa.
And who's appointed from the managing committee? Mr. Deb. Then you pay her from your funds. Simple as that.
Your Lordship, here, when this initially appointment there, Your Lordship, just was there, Your Lordship.
Where's para 2? Where's annexure 2?
Annexure 2 at page 8, Your Lordship.
Okay. Where's this place?
Statement, Your Lordship.
It's in Halideganj, this place, the school.
Yes, Your Lordship.
Okay. 17, 18.
7 Jimunesa is a SMC appointed teacher, Your Lordship.
Where, yes. Sanawal Islam contract, Devunessa Khatun SMC, Nitnadas SMC. And where is Sheikh?
Miss Lordship, that 5, Lordship. 4, Lordship. A Salam Sheikh. Contract.
You're on contract. Then? You're an SSA appointed teacher also.
SSA contract, Lordship. Because there is an order, because when that is why, my Lord, paragraph 2 of the paragraph.
Yes, then you are finished.
Your Lordship, here, he has been appointed Hindi teacher, Your Lordship.
We're not going to go there.
He was appointed Hindi teacher, Your Lordship. And then after this appointment and confirmation is there, Your Lordship. I'll bring all this record, Your Lordship. Even the inspection report whatsoever there, Your Lordship, I'll produce the inspection.
Are you on contract or you appointed by the managing committee?
So, Your Lordship, I am the founder teacher and then she is beginning and the teacher of this.
See, we just go 11 and 12 also. See, just go to page 10. You're there also, you're SMAC teacher and Salam Sheikh is contract. So he has a better claim than you.
Your Lordship, I am putting the approval.
So how was the question of finding same salary? Why are you confusing? You're saying that two conflicting court orders. His court orders only for his own post and hers for her own post.
The entire problem was created by the managing committee, Lordship.
You created the problem. You want to listen? Yes. No, they're correct. If for different posts, if it's for sanctioned post for Mr. Sheikh's client, you pay him salary in the government, and if you're appointing this petitioner from your own resources, they're not claiming the same post.
This is a Hindi post and then my is another post.
Lordship, I have the inquiry report again.
The inquiry report is not clear, you will say. I'll bring the whole inquiry report.
Yes. What?
Yeah, I'll just read it out, my lord. That, sir, she is the petitioner, my lord. She has been working as the assistant teacher in a non-sanctioned post by letter dated 3rd of February 2000 without pay till before her post was approved by the DSC SSA West Garo Hills by letter dated 30th August 2018, and the next DMC issued approval to Srimati Jebunesa Khatun as teacher of social studies.
Replacing me.
Not Lordship, I have the inquiry report. This is a.
It doesn't tally with the annexure 2 then. If it says that the last one, 2017-18.
Lordship, I have this report of 14 14th May not in the inquiry.
That is made by the managing committee. The entire problem created by the managing committee. Government affidavit is very clear. Who
Your
are
Lordship,
the
government person who has conducted the inquiry, Your Lordship, this report I will produce before this court.
You will produce?
I'll produce, Your Lordship. I am asking about it.
Let me finish up this matter today. Which page of inquiry?
This is a report of 14th May. This is the third internal page. To the district mission coordinator, SSA. This is done by the managing committee.
Inquiry took place by the government, Your Lordship. So this committee report, I will apply for it, Your Lordship. I will be getting very soon, Your Lordship.
The first paragraph I was reading.
It's clear by you only.
My lord, 1 minute if
Very
my
clear.
lord permits.
Yes, let him bring the inquiry report, whatever. After hearing at some length, it appears that after some length, Mr. R. Devnath praised him allowed to bring on record a copy of the inquiry report connected by state respondents to clarify the matter. It's a matter of 3 weeks.
In the affidavit, we have stated we have
Very good. But then if you go and appoint Tom, Dick, and Harry, and then that money you keep in your pocket, then
Your Lordship, problem has come up only due to this, Your Lordship. When this appeal come up and government has given the instruction, some cases they should be given to the individual teacher, and then I got the salary. And after that, and then respondent time then is the Hindi teacher, and appointment also a Hindi teacher.
Please, Lordship, this matter, Your Lordship, I was directed to file the document, Your Lordship, but however, Your Lordship, that secretary is not unwell, is not able to come. I may be given only
secretary is
2-3
unwell
days
or not unwell?
Not because I have prepared. I contacted also. I just pray only 2-3 days, Lordship. I will definitely file it.
Due to the Mr. P. due to the illness of the deponent who swear affidavit, may be allowed how much time? 1 week's time.
Lordship.
Prayers allowed for 1 week, yes.
May I just make a small mention? Two matters have, I think, been wrongly tagged with those batch of land acquisition matters. Item number 14 and 15 are not related to those Indo-Bangladesh border fencing cases. That is in relation to two-laning of National Highway 51 in Garo Hills. Mr. P.T. Sangh was appearing.
14, 15.
He has mentioned those two cases with the same batch.
14, 15.
Ranjang Mumin and Singhbhat. Okay, with item one clarification by Mr. Learned Senior Advocate, Mr. SN. Item 14 and 15 of previous hearing list stand detag from to other connected matters. You take care of the done.
Well, so far 34 is concerned, Lordship. I have got a objection.
34?
Time and again they have been taking time.
No, only past last
secretary is ill. He only has to bring on record.
This is the first time I
Since
asked.
it has been produced, Lordship, it can be taken on board, Lordship.
No, we have to take. You don't take judicial notice of it, a problem because you see the whatever orders have fallen. It's not that because you're in the regular employment. You have to understand. Yes. 1 week.
Yes.
Yes.
And 14 and 15, if any affidavit filed, then I have to file my affidavit in this matter. 14 and 15.
Let the matter be called out.
35.
35? Hearing? Okay. We'll call out 14 and 15 after the other matters in the hearing is. Yes.
Lordship, the conducting counsel is out of session.
Who are the sub-inspector of schools? After? When, Mr. Barsaji?
It's up to them, and I'm here.
Dr. Bozika is on holiday, it seems. He's on holiday?
No, Lordship, due to
Oh,
personal difficulty.
okay.
After 2 weeks, Lordship.
Okay, after 2 weeks. As another teacher, the council, city council is not available. Yes. Right.
36.
Who's for a petitioner in this matter?
Here, Mr. R. Majao is appearing for petitioner. R. Majao.
It not appeared now for many dates. There's one last chance. None appears without a petitioner. In interest of justice, matter stands adjourned to after 2 weeks. You don't appear next date.
37.
Let me say this.
Mr. Singh.
My lord, the petitioner, my lord, herein he was, he's working in the PWD, my lord, since the year 1987. And my lord, what has happened is, in the year 2019, my lord, in the year 2009, an order was passed putting, my lord, may kindly come to page number 13, my lord. The petitioner, my lord, who was initially appointed on master roll, my lord, he was appointed as a cleaner in the year 2009, and thereafter, my lord, in the year 2019, without any notice, without any so cause, my lord, he has been demoted from the post where he was working to the post of master roll, and by the same order, my lord, page number 14, my lord.
1 second. He does. This is on 31/10/2019. He's voted back on the post master roll.
No, prior order is 13, page number 13, my lord. That is his
1
appointment
second.
order.
Temporarily is cleaner. Yes, okay.
Thereafter, my lord, page number 14. Order number 34 of 2019. He is again demoted to his post.
No, but just temporarily you posted against the vacant sanction post.
My lord, here, my lord, why this order?
How many? 1009. 10 years you served
10
there.
years, my lord, I have been serving in that post, and thereafter, all of a sudden, my lord, they passed an order. That is 34 of 2019. And
Where is this Wallumbor Langkhoi?
my lord, he is being represented by.
You didn't file a case.
He is not, my lord.
I didn't challenge because we're not getting any benefit. Right? Same pay scale.
Pay scale is the same. My lord, even if this order is set aside, my lord, he is not going to be aggrieved. He will still get the same pay. Only in my case, my lord, previously I was getting 26,700. Now I am getting only 10,000, my lord. This is not sufficient for me to.
You can't be paid 10,000. That's impossible.
That is
No. Even Meghalaya revise the minimum wages.
My lord, my only submission is, my lord, I am getting only this much of amount right now.
Are you RCW?
My lord, I was initially I was appointed on master roll, my lord.
No, you'll get master roll fine.
Yes.
Yeah, now you'll be given as RCW. You can't get any relief, Mr. Chinkan. There's no question of any. There was no substantive appointment against the post. It's only the office
Against
order
the vacant
1009.
post, my lord.
See, in the interest of work, the person whom particular furnished bureaus hereby appointed temporary as a cleaner against a vacant post sanctioned by so and so. Because of sanctioned post, you enjoyed the regular pay scale. That's all.
Now, my lord, if
So
you
say
see
that
all the appointment orders, my lord, they give temporary. The word is always there, my lord. And my only submission is, my lord.
So in this case, see,
Unless and
what your reversion, it's not demotion. It was occasion because
of course, my lord, I was getting salary of 26,000. Now I am getting 10,000, my lord, and that too without any notice, my lord. That is against the principle of natural justice, my lord. That is why, my lord, this order should not stand, my lord. This order my only submission, if this order goes also, my lord, the private respondent, he is not going to be affected in this case. He will still get the same.
May I
Same
please,
thing,
your
my
lordship? I have annexed Annexure 1, page 6 of my affidavit, Your Lordship, signed by the Joint Secretary. Just Your Lordship, I will show Your Lordship.
Where Annexure 1?
Annexure 1, page 6. Page 6 and 11 page, Your Lordship, and page 8. List of dates along with dates and date of appointment.
Wait. When was this? Which affidavit? Filed when?
Filed by the, this is filed on 22nd April 2021. Filed by the Joint Secretary to the Government of Meghalaya Public Works Department. Boniwal Rapsang, Your Lordship.
Okay, yes.
Yes, Your Lordship. My learned friend is submitting that he has been working since 87. But Your Lordship, as per the list statement of their date of birth, he was born in 83, Your Lordship. Kindly have a look, Your Lordship. Kindly have a look. At page 8, I have given type copy also. Original page 64, serial number 64 at page 8, Your Lordship.
Yes, where's that?
64 page number, serial number 64, credit Marak, date of birth is 83, Your Lordship. And working from 1
There is
4.
not even a date of birth, my lord.
Yes, it is there, Your Lordship. Type copy is there. I have given furnished the type copy also along with this.
Only the year is mentioned.
So you said we were working in 87?
I thought only the year is mentioned.
No,
there is
Your
no
Lordship.
date also, my lord.
Your Lordship, first
The date
name
of
of
birth,
the
yes.
name
You
of
might
the.
not know the date, but you know the year. So date of birth, your
My
credit
lord, that
Marak
may have
is.
been wrongly recorded, my lord. Initially he was.
So how
he
come
was on
he has
master roll,
been
my
5
lord.
years? Since 5
And
years
they
he
have
has
not
been
No, wait,
joined.
1 second. Let's see affidavit. How old are you now?
Sorry.
Very interesting. How old are you now? Let's see affidavit. Is it about
39 years when case was filed. It was filed 2020. Case was filed in 2020. At the time his age was 39. As per affidavit, Your Lordship. But Your Lordship, heading of this page 7, though it is indistinct, I have given type copy, Your Lordship.
so? If he's 39, that means he was born in 1981.
If 81 also, Your Lordship, how come he 5 years?
No, if you're
87
I'm
he
going by
started
your
working.
statement. You say 39 on 2020, right?
Yes.
That means you're born 1981.
Yes,
So and where you said started working where?
87 he says started to
Since
working.
87.
Yes.
Child labor. When you were 6 years old, you started working. Now this demands no.
So he should have
Now you
started
see there in your statement is on. See, let's see.
They have not
Let me
produced
finish.
the records.
Yes, Your Lordship, I have. It
See,
is official document, Your Lordship.
Mr. Sankar is very serious on affidavit. You said that a petitioner works master role since 87 previously rules of
Yes,
record region. And next 1009 first. So he was born 81 as per your own statement affidavit. I'm 39 years old. So in 87 he was how old? He was 6 years old.
6 years old. How come he has been started working?
Could be the
Minimum 18 years is
yes,
required for
probably, my lord,
employment, Your Lordship.
may have been recorded wrongly. But even if my lord will see
This is very serious.
now, even if my lord will see the order
This is
of
very
appointment-
serious. Mr. This is perjury. You're bringing
This is
fact for the
official
court which
document,
is
Your Lordship.
not suppression. You're born in 81. Even if they say 80, maybe you're born 83.
Could be, my lord, this year has been wrongly recorded, my lord.
No,
by
this
me.
cannot be
It
because
could be
others
that also, my lord.
similarly
Now-
situated.
We'll send them to the lab for testing. You know they can have a test.
Yes,
to
yes.
test the age.
Teeth testing and other testing is there, Your Lordship.
Now, if my lord
Don't
will
argue anymore. As it is, you have no case. Number 2 is saying been working 6 years old. I record that the petitioner stated have been working since 6 years old, 1987.
I did not say, my lord, 6
You said
years
it. Your
old.
documents, your materials. 39 years old in 2020 when you filed the case.
My lord, it may be also that this 1987, this may have been wrongly recorded. It could be different years, my lord. Now, my only
See,
submission is
Mr.
if my
Sinkan, you can't play around the court. Your first appointment orders is 2009.
2000, my lord may kindly record from
Then?
2009 itself, my lord.
How,
Even then I was working for 10 years.
we cannot disregard this statement affidavit.
Even then,
It's on oath.
my lord, the
You
year
see, no
1987
laughing matter. It seems comical, but no laughing matter. It's on oath. That you said that he was going 87, born and on affidavit you sworn he's 39 years old.
My lord, only if I can make a small submission, my lord. I am only on the order which has been passed wrongly, my lord. Now, can the state
pleadings in
government,
the
my lord, pass
from
an
the
order without any so-called, my lord?
from the pleadings in the writ petition, at para 2, which is reproduced here and below. The petitioner has stated that he has been working as Mastorol since the year 1987. Stop. Reproduce. Approval of the affidavit filed by the petitioner when the incident petition was filed on 15 December 2020. The age of the petitioner is shown as 39 years. Stop. If these facts as put in the petition are correct, are taken to be correct, it would imply that the petitioner at the time was born in the year 1981, and as such could not have commenced working from 1987 as a master role when he would have been only 6 years old. Stop. Next, this court takes serious note of the averments made therein, which seem to have not been verified in a proper manner. Stop. Next paragraph. Coming to the facts of the case as put up by the petitioner. By the petitioner, it appears that White Office Order number 72/2009, he was appointed temporarily, against the vacant post of cleaner, and by Office Order number 34/2019 was reverted to its original post. Stop. The appointment of the post of the petitioner to the said post being of purely temporary nature and not by due process, no rights have accrued to the petitioner to claim for any hearing on being reverted, on being put back in the post to which he was appointed. There being no merit, reparations is dismissed.
May I please, Your Lordship? Your Lordship, before the main matter is heard, Your Lordship, actually I have filed one missed case, Your Lordship, in this matter for release of the salary of the petitioner. He has not been getting his salary from the month of January, only on the ground that he has not submitted his form for the new pension scheme.
Further?
He has not submitted the form for
Yes,
new
Mr.
defined
Valsadi.
pension scheme.
What instructions do you have?
This, I apologize, my lord, this keep my attention. Not if some time is given. This case
No, because stopped from January 23 only. Why you stopped it?
Your Lordship, they stopped it on the ground that we have not submitted the form for under new defined pension scheme.
Have you retired now?
No, Your Lordship.
Well, that must be a formality, my lord.
We listed on Monday, next Monday. You take instructions. Mr. Gibraji submits that due to inadvertence he forgot to obtain instructions on the Mrs. application filed by the petitioner. He prays for the Lord 1 week's time to obtain the same.
Much obliged.
40.
See, they've been paid from March, now it's already March been paid, now it's April. January, okay. Who's the paying for the respondent? You got instructions? Yes. What are instructions?
Since the land counsel for the respondent is not well, So, 6 times.
What's your name?
Florius Nangrum. P. Nangrum.
So first time you're appearing?
Yes.
You're who's junior?
P. Riatam.
You're submitting behalf Mr. Datta?
Yes.
Record this. This is the matter after 2 weeks to the unavailability of Mr. Datta. Counts for the respondents who is to obtain instructions. Who's to obtain instructions on the additional affidavit filed by the petitioner.
42.
Next time we tell him to be present.
Please proceed. It's actually regarding the compassionate ground, which is the old scheme last for the office memorandum dated 11/12/1984, Your Lordship. Your Lordship, it's from the record, it's find that petitioner, after the death of his father, he has filed an application and he was submitted, and they had found he was prima facie and genuine candidate. Later on, he was selected. Even he has gone for the test, and in that test he was selected. This on record, he was selected, and they found that he is genuine candidate. Later on, after that, the result was sent for the approval and for appointment, and after that there was no forthcoming from the state respondent. Therefore, petitioner has come before this court. I just like to lodge what happened actually is just have a look at the page 39 of my page 38.
No, 1 second.
Only just
30.
Page 39 of the petition. 38 Lordship, 30. Para 8 Lordship. Yes.
39.
Yes.
35.
38 Lordship, the relevant portion. This is the letter which is by the Under Secretary to Court of Meghalaya. Once this reading should be very clear to the courts, not to make us link this sufficient. In the para 8, we have they clearly stated that.
1 second, read from the beginning.
Lordship, from all this.
Prayer to decide the dispose of my application representation dated resurrection so and so and so.
Yes. May I take it from Annexure 7? In writing differences of this, I am trying to say that Rajiv Marak, resident of Rishum, Sierra Rishubet Paranotgar, has submitted a representative to dispose of his case for appointment on compassionate ground in compliance with the High Court order so and so. On through examination security of the order passed by the High Court of Meghalaya and the petition submitted by Sanjay Rajiv Marak, department observed noted following. As per the record available, it is observed that Rajiv, the petitioner, Rajiv R. Marak, had submitted an application for employment on compassionate ground in place of his deceased father, late Popular G. Movement, in the year February 2010, in the office of the Inspector General of Police, in Brigade TRPF AP, Meghalaya, Shillong. Now, this is very important in this paragraph, Your Lordship. As per the letter so and so on 17 June 2011, it is found that after considering the prima facie and genuineness of the case of the applicant of 292 candidate asked them to submit their application after enclosing all the available documents, whereby Rajiv R. Marak is also one of the candidates at serial number 65, Lordship. Here they are saying that he has been found genuine. The rest of the letter, you know, out of 1992 candidates, only 214 applicants appeared for screening tests, where 199 applied for the constable and 15 for followers. Those found eligible were allowed to go for the various tests on 18 and 19 February 2011 and 3rd and 27 May 2011. Para 4 says the Special Selection Board recommended to appoint only those who figure in the government list. The Special Selection Board feel that 292 new and fresh cases will be deterred and consuming scrutiny regarding the genuineness of their claim. Moreover, the board also felt that it should not go beyond the list given by the government. As per the minute of the meeting, so and so, the list of the person awaiting for employment compassionate ground was prepared, and department and department, and the list of 236 applicants was handed over to the AIG Meghalaya. Name of Rajib Armarak did not appear in the government list as his application was not provided to this department. As per the verification of the list, LGPTA so and so, the department-wide number so and so requested the Office of the Director General of Police to furnish all the relevant documents of the applicant which are not available in the department, including of Rajib Armarak appearing at serial 65, Lordship. The AIG white letter number so and so dated had furnished the available documents submitted by the applicant during the screening cum selection of all the applications, including Rajib Armarak appearing at serial number 65. Department dated 10/8/2011 was taken up.
So your case not disposed of.
Lordship, Lordship, may I take this? Lordship, I just take it their affidavit as one document.
No, now not disposed of. So what are you going to do?
Lordship, just have a look. This one, did you have disposed of? May I take the annexure affidavit 5 by my learned friend? It is page 88, relevant para your Lordship. What had happened, your Lordship? They have replied, your Lordship. I just only the last portion, your Lordship, is very clear. This letter was sent by Assistant Inspector General of Police, Lordship. Page 89. Page 89 of the affidavit filed by the state respondent, Lordship. Page 89, last portion, just he has, AIG has made an observation. He has requested the other secretary to consider my case, your Lordship. Just page 89, that affidavit filed by the state respondent, Lordship. In the last para, he says that there's stating that
that's not nothing decided.
No, Lordship, just
there's no positive order for your appointment.
No,
and they're not appointing you.
No, Lordship, just want to make it clear. Just want to read this one. In view of the above fact and circumstances of the case, it may be stated the applicant appeared to submit an application as he has appeared for the test bearing roll number 55 instead of 35 as for list. The further, due to administrative lapse, the applicant cannot be made to suffer. Therefore, it is requested your kind office to kindly consider this petition and process the matter as deemed fit, Lordship. That means they are saying that petitioner is eligible, he have appeared for the test, documents are submitted, but in this letter,
how old were you when you submitted, when you applied for
at the time, it was in the year of 2011. Now I'm already around 32 because as per the record, he was born in 1983.
83 you were born.
Lordship.
So you'll be 30 years old.
Lordship. Because now at that time, my case is here, Lordship.
How do you survive now for 10, 11 years?
Yes, Lordship, that is actually just he is an employee. Is just
no. How do you survive then?
Going on daily wages.
Who is he to the deceased employee?
He is the father. Actual father.
How was the family supporting itself after father died? Are you getting family pension or not?
No, Lordship.
You're not getting family pension?
They're getting, Lordship. I think to some extent.
How are you surviving for 10 years?
Lordship, of course, he's just going for some daily work, Lordship. But Lordship, the point of the legality is that department they have admitting that.
No, that is not the point. The thing is that compassionate ground is on a different, footing altogether.
Lordship.
Compassionate ground is court always observe, is given as a way of, immediate help.
Lordship.
So that family will not be destitute, won't be thrown in the streets. And so as the years progress, then your claim of compassionate ground always, it decreases, As the sun sets slowly, even your claim also sets slowly.
That's what, your Lordship, I agree, Lordship.
You agree, of course. Very good, you agree. But that is the, and so what happens in these cases is that, sometimes when they reconsider, you'll not be, what do you call it, eligible any longer.
But they
have to undertake the exercise, number one.
But they are not, Lordship, yes, Lordship, I correctly understand what you are saying, that I agree, but they They have never stated that he is not eligible, now he is not applicable. Those things they have never come up with that.
No, now what do you want this
And
case?
even
Because
till today, Your Lordship,
we want another mandamus to them to consider. Once already one round finished, consideration still in progress.
Even on recently, Lordship, I think we can await this one. On 27 March 2022, still they have a written letter to
27 March 22 or
yes,
23.
2023. Still they is asking to submit all the document. That means still they are considering. I have this letter, Your Lordship. Actually, I let me just get instruction on this letter because if Lordship, I find an affidavit also to this effect. This is the letter.
What does the government
issued
say?
by the Under Secretary of the Government Meghalaya, letter dated 27 March 2023. They are asking still the document. That means still they are considering.
Why they asking? You know, why they asking, Mr. Sama?
They're asking that.
No, why are they asking?
Here it is
It's been 12 years since the scheme also was over. Of course, he applied when the scheme was still there. Why they asking? You know why they asking? Why?
But they're
No, just ask yourself. Why they asking?
According to my understanding, that they are asking to submit the document
Why?
to consider the.
Why is the real reason they're asking? Real reason is because they're scared because the matter's in court. That is why they're asking.
That is not because of scared, because this is second time of petition, Lordship.
Yes.
May I please, Your Lordship? Lordship, as per the 1984 Office Order on Compassionate Appointment, Para 12 clearly states that it is not to be allowed as a matter of course. The financial circumstances of the family would be taken into consideration for eligibility. Furthermore, Lordship, what has happened is that after they had applied for, they had filed the representation, the screening test was held in the month of January and May. Then thereafter, Lordship, I would like to refer to page 12 of my affidavit, where it stated that the petitioner had not submitted some necessary documents with regard to the financial position and the grounds for his applying for that. So there were also lapses on his part when he first initially applied also, Lordship. Moreover, with regard to compassionate appointment, as your Lordship has stated, Lordship, this is the main reason that compassionate appointment is given is to elevate the financial hardship, immediate financial hardship. The father passed away in the month of February in 2010. Then the first time that he approached the court was in the year 2020.
No, it doesn't matter. Now, only one question. So, compassionate ground, that means you'd be made a constable. That is your claim, correct?
Constable or any
No,
post.
in the police will be constable.
Yes.
So now suppose it was screening test now. Court directs that. What's the name of this candidate? Rajiv Marak. Tomorrow shall appear before the SP, concerned SP, to do the physical test. Will he be able to? He be fit to run?
Lordship,
That time, 2011, poor fellow, he must have been fit. He was 20 years old. He could have run. Now, because all these tests or recruitments on physical fitness, will he be able to run 20 kilometers?
Lordship, it is to that effect.
You can take instructions.
It is. The AIG himself has already clearly admitted.
He might have passed screening at that time.
Yes,
You have to look at the practical aspect. Now, suppose you are asking, suppose you say yes, we can consider for his appointment, right? Then they ask you to do screening test. What happened? Will you come to court again and says no, you can't do screening test? I've already run 25 kilometers 10 years ago. I'm not going to do it again.
About any other post also, but still we can go that. But they have admitted because they say that the document has been submitted due to the lapse of the administrative, Lordship. They have stated that. Anyway, Lordship, I only have been there. Some other court order also from this covering case because they have considered because they did not deny this. They have the judgment from this court only.
What are the considered?
I just let it because of course this may not be relevant, but I feel it is because I have this one also. I plaque it marker also that cross it also.
No, it's not a case of rejection. You understand?
Yes,
that is why.
yes.
How will you pass orders? It's not a case of rejection by them. It's that they're still considering.
Lordship, let them come. I will get on instruction on this letter dated 27 March. Any outcome, give me 1 week time then, or 2 weeks.
Lordship,
We will see to what happened to that. any outcome. There are others, just
See.
what are also.
This case is totally different. This case, what happened was this: the husband died in 2009. Immediately, the wife applied, and on a piece of application, he was fit. He was recommended for appointment to grade 4. But after recommendation, is not appointed. Then came to the court. Court said after you found her fit, appoint her.
Here also,
But out here after
actually,
10 years,
here also the case was same actually, but only thing is, as admitted by the
there's no
AIG,
final order that says that you're fit. Correct. And you qualify in other respects.
No.
They're still considering, will not get anywhere. What do you want to do?
2010, my father died. On that year itself, I apply application. It is on record. And on 2011, case has been taken. I was considered, and they have sent it for their approval. But it is they have, due to the administrative blood means they saying that I have not submitted the documents. Submitted only on the ground. They were saying that they don't even say that you are not fit. Lordship. Anyway, Lordship, I only pray for any instruction, Lordship. Maybe I may withdraw or whatever. Just
No,
give me
I'm not going to withdraw.
once last chance. Just I will get the instruction from the client for the interest of justice, Lordship. Later on, any submission, whatever we
Yes.
can do.
Lordship, at page 28 of a counter affidavit, where the recommendation of the special selection board is listed at the last paragraph, it clearly states that the board feels that the 292 new and fresh cases as indicated in paragraph 5 and 6
Already
will
read
need
out,
more
Lordship.
detailed,
I have written
more
that.
detailed and time-consuming scrutiny. The petitioner had just appeared for the screening test, and there was never any recommendation for his name to be for appointment.
To that effect, because the AIG, that letter he has already clearly admitted, due to the lapse of the administration, the petitioner should not be made to suffer. That means they are admitting, Lordship.
What
they are
admitting?
that-
Don't be
that
to suffer,
letter-
means suffer to wait whether you get appointed or not. That's all. Not to get
It
appointment.
is not my word, Your Lordship. However, Lordship, for it, let me just get the instruction.
What instruction?
Because there's latest development was there. That letter I have shown because I wanted to place it, but since it's not clear. So maybe if Lordship permit, I will just file it for the record. Also that letter. Maybe I'll just get the instruction, Your Lordship, after 1 week.
Did you when you submitted your form? See, we are giving a lot of hearing because we have lots of time. It's only 12:30. Now, when you submitted your compassionate application, did you give the prescribed form?
Yes, Lordship, it is there.
Everything.
Everything was there.
Did you give all the details
Everything was there,
to
Lordship.
enable them to consider that relevant point of time within 1 year of the death of your father?
According to me, that on record, they say that they have submitted everything, even the financial position.
Everything.
Everything.
Lordship, at page 20 of our paragraph, it's reflected that the application form for employment on compassionate ground not
But they said-
available, particulars of dependent.
I beg to repeat that letter. They said because they received all the document. They are themselves admitting that due to the administrative lapse. That means the document is there, but they have misplaced it. Indirectly, they are admitting all the documents have been submitted to them, and they are even requesting since because of the mistake of the administrative, it should not be suffered. It should be allowed, and matter may be processed. And that statement is made by the AIG, you know.
Yes.
Lordship, we would also like to place before your Lordship a judgment where, in a similar fact, where the petitioner had approached the court after a lapse of 11.
By this court?
No, your Lordship, a judgment of the Supreme Court.
It is not because of the. It was.
How?
pending.
When did you come to court?
No, we actually.
22, no?
Not 22. Actually, before coming to the court, we were exhausting our remedy before the department. First
you filed a petition. First petition when?
There was some legal notice. Actually, everything was there in that letter mentioned by the AIG. May I take there in their annexure only they have submitted.
You came
that.
first time in 2020.
Before that also, this one is that letter. They here, Lordship, in the annexure, page 88, annexure 4 of the affidavit filed by my learned friend. Everything was reflected. The process has been started from first they went to RTI, then finding the legal notice and so and so. That relevant para, this one, para 3, they have stated, Lordship. He has been pursuing the matter with the department. It is not that case, but finally he has come to the court.
Well, listen, after his death, when did you file? When your father died, when did you file your application for compassionate appointment?
On February 2000, on the 2010,
On the year
10
itself.
itself, 2010 itself. Then 11th on May 18, 19, March 1918, there was a TIS interview, Lordship. And they said I was found prima facie as a genuine candidate, and they have sent for verification and for approval.
Did you
After
pass
that,
a physical screening test?
Lordship, I passed. I passed.
But then you see, the thing is that is why this court's asking, how do you survive for 10 years?
Lordship, that is, of course, yes, financial position, of course, but then Lordship...
He's a cultivator or what, businessman?
No, he's just, he don't have any job, he's just whatever he get. But I even stated in my petition, he's suffering a lot from financially. Nobody is there to support the family. Of course, people, they have to survive by doing all, does not mean that...
Yes, of course.
That is okay.
Where's the petition? Where's your application? Where's the, what to say? Sorry.
Application,
wait.
Lordship, they have, that first application was, it is on the, with the office only, but then my learned friend has enclosed the affidavit, all the document application form also, it is on the page
Where's the one that you apply your application?
My application.
Where is it? Page 92 of the affidavit.
Page 92 of their affidavit.
Okay.
But this was submitted after, because he was asked to submit, but prior to that he has submitted. In the affidavit filed with the government.
The initial one.
Initial one, it is with the department, Lordship. Then they have misplaced it and again asked the petitioner to resubmit. And he has submitted this 91. They have stated that submission of document in respect of Rajiv Armarab. 91, the affidavit filed by that page 91.
Forget it. Enough. No, I want to know when was the date when you submitted your first application for compassionate appointment?
They have mentioned in that letter, Your Lordship, that the same way I read, Your Lordship, this one.
Where we mentioned in your pleadings? Where is it mentioned?
In my pleading also I have mentioned just my application. In my application. Yes.
February 2020.
Yes, para 5. Yeah. Para 5, I have mentioned, Your Lordship, after the death of the petitioner's son, late so and so, submitted on month of February 2010, in place of his deceased father, to appoint him as a police constable, compassionate ground, in the year of 2010 only. And then later on, the interview for the post of police constable was conducted on 18 February 2011, 19 February 2011, 3 on 3rd May 2011, and 27 May 2011, Lordship. All that tests, yes. That means before rule is they admitting, before test, Lordship, they have asked to submit all the document. After verifying the document only, they have allowed us to go for the test. They have examined the document, they verified the document. After submitting the document, after verifying all the document, they have allowed us to take part in the test, Lordship. If that is
what is the age limit for appointed constable?
That I'm not aware.
Any idea, anybody? Constable, what is the upper age limit?
As per the service rule, but the relaxation actually that 30 years is this one the
Possible.
And yes, moreover it was relaxed. He's moreover is ST tribe, and then still now he's 30. So and age can be for the STs can be relaxed by 5 years. But I actually for maybe there is a specific age for the constable, but I'm just saying from the service rule it is there, Lordship. 30 is the this one. If the 30 age also can be relaxed, that age can be relaxed. 5 years can be relaxed to the ST, Lordship. But there may be specific age for the this one. But my learned friend may be able to know because he's from the department.
He's the police department.
No, I mean this appearing is
Oh.
I'm just saying.
So your representation was the first time on 10/10/2019 you filed.
Before that,
Did you?
before that they send a legal notice.
No.
somewhere in the year. Yes, the representation is on the basis of the direction from the court, Lordship.
10/10/2019.
Yes. Before that, he has approached.
Direction from the court.
No, before yes, there was earlier also he has filed a case and the court directed to
No.
file a representation before the.
When was that? Which was the first time you filed
The
the case?
decision is there, Lordship. Yeah. See, I have annex also in the annex 4 of that earlier court order. It was on the 2021. Then
No.
based on this court order, he filed a representation.
I'm talking about your representation. Which one is the first time was it filed? See, yes. 10/10/2019 is the first
Yes,
time you
sir.
represented. That means 9 years after you applied for the post. Over 9 years.
I see. But prior to that, he has been.
Take down. Yes. The brief facts of the case are that yes.
Lordship, I'm instructed by my colleagues that as per Google, the age limit is 27 plus 5 for ST category.
So he's still fit. He can
Lordship.
run 50 kilometers.
Yeah, Lordship, I can run.
He can run. No, you can run. I know, but I'm your client.
My
He can
client.
run. He can run. Yes.
Lordship, I'm also instructed that there is a notification of February 2022 with regard to this age limit. It's 32, Lordship.
32.
For the police department.
No, for constable.
Yes, Lordship.
No, I'm only 29, Lordship. 29.
Okay, take down the brief facts of the case are that the petitioner before the withdrawal of the compassionate scheme of appointment on the death of his, where's your synopsis? On the death of his father, who was serving in the police department. On the death of his father on February 2010, who was serving in the police department, had applied for appointment on compassionate ground in the month of February. How come you applied? When did your father die? What is die, Nanis? Yes.
Lordship, at page 106 is 21/2/2010.
He died.
As per the death certificate.
And when did you submit your application?
On the year of 2010, he said.
You said February. That means before your father died.
No. After my
After he
father
died.
After that.
Naturally, this no. Before that? Had applied for appointment on compassionate ground. Stop it. Stop. It appears thereafter the petitioner had appeared for a screening test and also for interview, which was conducted on the months of February and May 2011. Stop. Thereafter, as nothing transpired, the petitioner filed the representation on 10/2019 for consideration of his case, and thereafter his case, which however did not evoke any response. Correct?
Lordship.
Being aggrieved thereby, the writ petitioner then approached this court by way of WPC number 69 of 2020, wherein this court, by order dated 20/4/2021, directed the respondents to decide the petitioner's representation dated 10/10/2019 on his own merit and in accordance with law. Stop. Next paragraph. The respondents, in compliance with the order of this court, then disposed of the representation on 4/2/2022, which however was inconclusive, as the relevant records of the writ petitioner were not available, which were required for consideration or set employment. Stop. This unscattered respondent number who? Respondent number, unscattered home police department. Respondent number, the respondent number 2. While also the number 2, while disposing of the representation, then requested the Director General of Police to furnish him with the required comments to enable a final decision in the matter. Stop. What's the next document you said?
There's 89 there. 89. They have replied to that one. Page 88.
In the affidavit.
In the affidavit.
From the affidavit of the respondents.
Page 88.
From the affidavit of the respondents, a certain correspondence dated 7th July 2022.
The last para they have.
with 22 has then have what it have enclosed the submit by certain communication,
Affidavit of the respondents asserting correspondence dated 7 July 2022 has been
which appears at annexure 4. Appendix 4. It is seen that the documents in respect of the writ petitioner had then been submitted to the respondent number 2 for further consideration and for process of the matter as it deemed fit. Stop. Next paragraph. Not same paragraph. However, as no further orders were forthcoming, the writ petitioner has again approached his court by way of the instant writ petition.
Gotcha.
That's correct?
Gotcha.
Yes, next paragraph. Mr. P.T. Sangma, counsel for the petitioner, submits that firstly, the application for compassionate ground had been made had been made in time and was not delayed in any manner, and that when not in any manner. Stop. He further submits that the petitioner also was found fit for appointment after the screening test that was held by the respondents for appointment to the post of constable. He contends that the inaction of the respondents has caused grievous harm,
Gotcha.
as in due course, if his case had been considered, he would have since attained employment on compassionate ground. Stop. Your submissions. MS Thungwa for the respondents has firstly raised the ground that the case of the writ petitioner is hopelessly delayed, inasmuch as the screening test had taken place as far back as in 2011, and the representation which was taken into consideration was filed only in the year 2019. Stop. He further submits that the delay in consideration cannot be attributed to the respondents, as vital records were not submitted by the writ petitioner for consideration at that point of time. Stop. She lastly submits that compassionate ground, compassionate appointment being a means to alleviate the suffering of financial suffering of a family due to the demise of breadwinner. The grant of such employment is to be determined by assessing the financial condition of the family at the relevant point of time. So, the councils also placed the decision of the decision of the Honorable Supreme Court reported in 2006 5 SEC page 766.
Paragraph 11.
Yes.
Paragraph 11, 14 and 16.
Wherein it has been held that delay, the consequence of delay, and latches the petitioner of where it is compassionate ground is not cannot be afforded. Stop. Next paragraph. Or stop here therefore submits that on account of the delay and latches of the petitioner, no cases are made out for consideration, and the petitioner is liable to be dismissed. Stop. Next paragraph. I have heard legal counsel for the parties and examine the materials on record from perusal of the same. It is true that the petitioner had made an application for consideration for compassionate employment well within time and immediately after the demise of his father. Stop. It is also not disputed that the petitioner appeared for a screening test. Stop. However, what transpired after the initial application and selection is not known, nor did the petitioner pursue the same till 2019 when the petition was filed. That is a good period of 8 years. After a good period of 8 years had elapsed after the said application and screening test. Stop. The respondents, it is noted in their reply and in the consideration of the case of the writ petitioner, have processed the same, but it remained inconclusive, apparently due to the fact that the matter was not pursued by the petitioner and as such had been left in cold storage for a considerable period of time. Stop. The subsequent activity with regard to the consideration of the case of petitioner came to be only after the order was passed in the earlier petition and the records were sought for. Orders passed when the directions were passed when directions were issued for disposal of the representation. Stop. This court, while considering the case of petitioner, cannot lose sight of the fact that an appointment on compassionate ground is an exception to the general rule of appointment and should be made and can be made only in consideration of certain parameters. Stop. One of them, the certain parameters such as financial situation and suitability of the candidate. Stop. In the instant case, though the petitioner had applied within time, the very fact that he did not pursue his case for respondents shows that he maybe was not under such financial constraints. However, be that it may, the aspect of delay, therefore, also can it be overlooked? Stop. On another stop. The respondents, as noted earlier, though having initiated the exercise for consideration of appointment, did not conclude the same in time to warrant any did not conclude the same in time to enable them to pass any effective orders. Next paragraph. In this backdrop, taking into account the scheme, taking into account the concept of compassionate appointment and the rights of the petitioner, which have been alleged to be violated, this court will dispose of this court in consideration of the facts and circumstances proposes to dispose this matter as follows. So, right, A. As it is evinced from the records that the respondents are still considering the case of the petitioner, the said consideration shall also keep in mind the requirements of such an appointment, and also whether memorandum
page one of my memorandum. Annexure 1, page 25. Page 25 of my writ petition. Memorandum. Office memorandum. Annexure 1.
Page
25 of my writ petition.
As it is evident from the records that the respondents are still considering the case of the petitioner, is that consideration shall also keep in mind the requirements of such an appointment
and also the demands of also keep in mind. What? Sorry.
Keep in mind the requirements of such an appointment and also
appointment being an appointment which is exception to the rule, by taking into account the factors such as delay, fitness of the candidate, financial condition, and what else? And that delay We're distracted by the lights, huh?
Taking into account factors such as degree, fitness, or temporary financial condition,
And other attendant factors such as suitability and eligibility. Stop. Next part. One important fact or another important aspect. I think it covers it. Yes. Yes. Because actually you don't deserve consideration, but because of the correspondence only, that this, that is still under active consideration. So otherwise you should not be considered anyway. Note that with the above noted directions, the repetition stands closed and disposed of. It's expected that the exercise should be completed, preferably in a period of 6 months. But yet this order is presented before the respondents. Yes.
Hi, Williams.
14.
Yes.
14.
Is that regarding that only where national highway and land compensation, they say that should not be together. This 14 and 15 actually is a national highway. That the rest of the matters are connected to the board of Bangla
Yes,
border.
that's fencing. This is not fencing. So, yes, Mrs.
14
Devnath.
and 15 is regarding to widening of National Highway 51, my lord. And in number 14, my lord, we've already filed our affidavit in which we have stated that this number of petitioners, my lord, they are around. My lord, they do not, first of all, my lord, they are not the actual landowners. So the actual landowners have been already identified by the state government, my lord. And to them, my lord, the processing of land compensation has already been started. I believe, my lord, few of the owners must have already been given also, have accepted also. So these people are not the actual landowners, my lord.
To that effect, I'm waiting
They
to
are
file the rejoinder, but
193,
others responded, they have not filed the affidavit. That's why I will be filing my rejoinder because whatever stated.
In the hearing stage, what rejoinder?
No, it's not for hearing
No,
lordship,
it's
it's
for
for
orders.
order lordship.
It's for orders.
Only for the
Oh,
orders.
yeah, then okay.
In this case, they just file the affidavit. If they provide us one copy of the file.
Yes, you kindly provide copies.
Whatever we provide.
State to share affidavits with other respondents, and also Mr. P.D. Samma allowed to file rejoinder
sure.
affidavit filed the state. This after 3 weeks.
High level evidence. First place.
Yeah.
My lord, apologies, my lord. I crave my lord's indulgence. At item 33, my lord, earlier I had mentioned. My lord, because till the last occasion, my lord, the interim order was extended. On the last date, my lord, my junior colleague had appeared because I was unwell. So that's why perhaps she forgot to mention the stay, my lord.
Nothing will happen.
Because I'm in possession of the shop, my lord. That is the thing.
Arandam Kongthorem.
Yes, my lord.
Nothing will happen to him for control. They won't do anything.
My lord, kindly, my lord.
What is that?
This is the, I'm...
Mention memo.
No, my lord, this is the order dated 15/3. It was last extended, my lord. On the last occasion, because I was down with fever and all, I could not come.
So which item is it?
My lord, item 33.
Yes, the interim order shall be sent to next date. Yes.
Much
My
obliged.
apology, Lordship. I missed item number 36, Lordship. I missed it, Lordship.
Yes. So what can we do, Mr. Maja?
So urgency in this matter, Lordship.
Matters, orders all been passed.
Matter can be taken
Why
tomorrow.
are you not here when the matters called out?
I was talking with the senior counsel on the opposite lawyer, Your Lordship. This matter can be taken tomorrow, Your Lordship, because the petition is very sick in this case. He's in the deathbed, Your Lordship.
What's the matter?
Item number 36, Lordship.
We'll take it after then. Yes. 36. None appears for the petitioner. So this is matter and it's justice. Because I'll tell you, Mr. Majao, last he checked the order sheet.
Yes, Your Lordship.
Last date no one appeared also. Now how is this urgent?
Like Lordship, the then senior counsel was under disposed, Your Lordship, and they informed me that they'll be adjourning the matter, Your Lordship.
The last date before this.
Yes, Your Lordship.
That doesn't mean that you make a representation. Someone should be present on your behalf.
Yes, Your Lordship. My apology, Your Lordship.
We look at the orders. We look at the orders. Now you come and say it's urgent and you don't bother to appear the last date.
My apology, Your Lordship. It won't happen again, Your Lordship.